Do you need to disclose to a home buyer that the house you are selling is haunted? Welcome to the Fox Hollow and my Spooktacular Halloween special. My name is Skylar, and this is Legally Drunk, the show where I get legally drunk and rant about the law. Remember, I'm a lawyer, but I'm not your lawyer. Nothing in this video constitutes legal advice. If you've got a problem, please consult an attorney in your area. This evening, I'm drinking blood. Just kidding, it's like a red wine. I'm always looking for legal themed, law themed alcohol suggestions. So if you have any ideas, please put them in the description. No, not the description. Gosh, how many wines have I drank already? How much blood have I drank already? No. If you have any legal themed alcohol ideas, please put them in the comments section down below. I will check them out and I will use them in my videos and give them a review. So this evening, we are delving into the eerie swamp of court cases to answer this question. When you're selling a house, do you need to disclose that it's haunted? It may seem absurd because unless you believe in ghosts, which may be the case, most of us wouldn't consider disclosing something which in reality doesn't exist. Ghosts. You may be spooked by the court's answer on this one. The case, Stambovsky v. Ackley, which went up to the New York Appellate Division, decided in 1991. The facts of the case? Well, the home was called the Lavetta Place, located in Nyack, New York on the Hudson River. The house had been vacant and in disrepair when Helen Ackley and her family moved into the waterfront home in the 1960s. Local children purportedly warned them that the house was haunted, though no prior paranormal incidents appear to have been published. During the course of Helen's home ownership, they reported the existence of numerous poltergeists or ghosts in the house to both Reader's Digest and a local newspaper on 3 occasions between 1977 and 1989. And the house was included on a 5-home walking tour of the city. Helen Ackley claimed there were at least 3 ghosts living in the residence. She described 2 as a married couple who lived in the 18th century and the other as a Navy lieutenant in the American Revolution. In 1993, so after the case was decided, she was contacted by paranormal researcher Bill Merrill and medium Gwen Johnson, who claimed to have already made contact with 2 of the spirits at the Lavetta Place. They met with Helen and disclosed that the couple were likely the poltergeists of Sir George and Lady Margaret, who lived in the region in the 18th century. In 1995, Merrill and Johnson published a book about their findings entitled Sir George, the Ghost of Nyack, which I guess you can find on Amazon still to this day. Ooh, spooky. Helen claimed to have seen Sir George, saying he was, quote, sitting in mid-air, watching me paint the ceiling in the living room, rocking back and forth. I was on an 8-foot stepladder. I asked if he approved of what we were doing to the house, if the colors were to his liking. He smiled and nodded his head. Spooky. Helen described other creepy stories of how the ghosts interacted directly with her family members, claiming that grandchildren received gifts which later suddenly disappeared. Phantom footsteps, slamming doors, and hearing conversation from a vacant room. One ghost was alleged to have wakened Helen's daughter, Cynthia, each morning by shaking her bed. As ghosts do, you know, those sneaky rascals. But the ghosts are actually pretty cool sometimes too, because when Cynthia asked the ghosts not to wake her up early, when she wanted to sleep in during her spring break, the ghosts honored her wishes and didn't shake her bed in the morning. Now, why she didn't ask this every evening before bed is beyond me. I guess she liked using the ghosts as an alarm clock. No judgment, that's chill, that's cool, whatever. You know, they're friendly with each other, it's cool. Blood. Mark Kavanaugh lived in the home briefly while engaged to Cynthia and recounted the spookiest experience of them all. He said Cyn, as in Cynthia, had already fallen asleep and I was drifting. Then I heard the bedroom door creak and the floorboards squeak. My back was to the edge of the bed. Suddenly, the edge of the bed by my midsection depressed down, and I felt something lean against me. I went literally stone stiff. I was speechless and could hardly move. I was able to twist my neck around enough to see a womanly figure in a soft dress through the moonlight from the bay windows. I felt like she was looking straight at me. After about a minute, the presence got up and walked back out of the room. I finally relaxed enough to shake my wife out of sound sleep, acting like a toddler who just had a nightmare. Spooky. Very spooky. So all but Kavanaugh's accounts were written by Helen and submitted to Reader's Digest magazine and published in its May 1977 issue. Despite these somewhat unnerving tales, the Ackleys said they had a peaceful coexistence with the ghosts, and the only account of any terrorizing event or anything like that is Kavanaugh's story, which I just told you. Kavanaugh later reflected on the incidents that he experienced and came to the conclusion that the ghosts were evaluating him to make sure he was a good suitor for Cynthia. Again, those ghosts are rascals, but I guess they make good friends to Cynthia, like some Casper the Friendly Ghost nonsense. I mean, that's chill and no judgment. They seem very protective of Cynthia, allegedly. Blood. Eventually, it came time for them to sell the house. As families do, sometimes you move on and you move away. So when it came time to sell the house, neither Helen Ackley nor her real estate broker revealed the haunting to Jeffrey Stambovsky before he entered into a contract to purchase the house. Stambovsky made a $32,500 down payment on the agreed price of $650,000 for the house. He was from New York City and he was not aware of the folklore of Nyack, including the widely known haunting stories. But when he learned of the haunting story, perhaps he was superstitious, or he didn't want to deal with it, or he found a better property elsewhere and wanted to get out of the contract, he filed an action requesting rescission of the contract of sale for damages for fraudulent misrepresentation by Ackley and Ellis Realty. He refused to attend the closing, which caused him to forfeit the down payment, but then he was not obligated to buy the house. A New York trial court dismissed the action, and naturally Stambovsky appealed the decision. The Ghostbusters ruling is widely taught in law school because it's just really weird. And also the justices on the court have a lot of fun, like way too much fun with it. And because of that, it's a case often cited too. So therefore you want to teach it in law school. And it's kind of a good lesson on a lot of basic concepts in contract law and equity. So, you know, it's kind of foundational. Throughout the case, the justices make references to many popular books and films featuring ghosts, such as Hamlet and the 1984 movie Ghostbusters. They use phrases like, "Plaintiff hasn't a ghost of a chance," and I'm moved by the spirit of equity. And the notion is a hobgoblin, which should be exorcised from the body of legal precedent. Very colorful language by the court here. So humorous cases like this honestly make it possible to endure the horror story that is law school, where law students otherwise skulk about like zombies, downing coffee and moaning about our lot in life. True story, when you graduate law school, your soul forever remains there, haunting the halls of your alma mater. Woo! Blood. So the court concluded, quote, having reported the ghost's presence in both a national publication and the local press, defendant is estopped to deny their existence, that is the ghost's existence, and as a matter of law, the house is haunted. The court explained that regardless of whether the house was actually haunted or not, the fact that the house had been widely reported as being haunted greatly affected the property's value. The court affirmed the dismissal of the fraudulent misrepresentation action and stated that the realtor was under no duty to disclose the haunting to potential buyers. Thus, no damages were available to Stambovsky because New York at the time adhered to a property law doctrine of caveat emptor. Now, caveat emptor basically is Latin for let the buyer beware. It's a contract law principle that controls the sale of real property after the date of closing and may also apply to sales of other goods. It's used as a disclaimer of warranties arising from the fact that buyers typically have less information than the seller does, in this case, about the property. This creates information asymmetry, where defects in the house may be hidden from the buyer and only known to the seller. The buyer can't recover damages from the seller for defects on the property that rendered the property unfit for ordinary purposes. The only exception was if the seller actively concealed latent defects or otherwise made material misrepresentations amounting to fraud. And that wasn't found in this case. But the appellate court did reverse the trial court's decision regarding the rescission action, as it explained that haunting was not a condition that a buyer or potential buyer of real property can and should be able to ascertain upon reasonable inspection of the property. I guess you'd have to hire some sort of paranormal professional for that.
Something strange in the neighborhood. Who you gonna call? Ghostbusters!
The doctrine of caveat emptor would normally bar a rescission action, causing the seller to have no duty to disclose information about the property to be sold, and also preventing the seller from affirmatively misrepresenting the condition of the property. However, the doctrine in a merged law and equity system can be modified to do justice to the parties. So in this case, the court said, quote, the most meticulous inspection and search would not reveal the presence of poltergeists at the premises or unearth the property's ghoulish reputation in the community, unquote, and thus equity would allow Stambovsky the remedy of contract rescission against the seller, Ackley. Equity is basically a really terrible fail-safe involved with civil law and particularly in contracts. So equitable doctrines are distinguished from legal ones. And this is all from English common law. And I say it's a terrible fail-safe, not because it is bad in concept, I think it's fine, but because usually it doesn't work out. Usually the court isn't gonna find an equitable remedy. It's kind of a difficult conclusion to come to. But if you do get really weird cases like this one, where there isn't a sufficient or adequate legal remedy for the person, because it's such a strange situation, the court can redress the situation with an equitable remedy, like this one. So the court held, quote, where, as here, the seller not only takes unfair advantage of the buyer's ignorance, but has created and perpetuated a condition about which he is unlikely to even inquire. Enforcement of the contract, in whole or in part, is offensive to the court's sense of equity. Application of the remedy of rescission with the bounds of the narrow exception to the doctrine of caveat emptor set forth herein is entirely appropriate to relieve the unwitting purchaser from the consequences of a most unnatural bargain. Unquote. The dissenting opinion thought the doctrine of caveat emptor should be strictly applied and would have affirmed the trial court's dismissal of all the actions. The dissent was pretty salty about the majority's holding, and they explained, quote, if the doctrine of caveat emptor is to be discarded, it should be for a reason more substantive than a poltergeist. The existence of a poltergeist is no more binding upon the defendants than it is upon this court. Unquote. Well, the case generated a considerable amount of publicity, and area real estate agents had between 25 and 50 potential buyers calling within a week of the court's decision. Interestingly, among the prospective buyers to the house at Lavetta Place was Kreskin, a renowned mentalist, who wanted to purchase a haunted house in which to curate his collection of paranormal paraphernalia. Helen Ackley sold the house to another buyer and moved to Florida in 1991. She died in 2003, and her son-in-law believes that her spirit has taken up residence back at the old Lavetta residence. But apparently, there have not been any public reports of hauntings in recent years. Merrill and Johnson, remember those guys that wrote the book that's on Amazon? They reported that Sir George and Lady Margaret expressed that the spirits were apparently not as fond of the new owners and were thinking of moving on. It's also reported that after the judgment against Helen in the lawsuit, she claimed that she was moving and taking the ghosts with her. So, maybe she and the ghosts are not at Lavetta Place, but at the new Ackley residence in Florida. Or, just maybe, they all moved on from this world together. What do you think about this case? Was the Ackley house actually haunted? Do you think you should disclose, or have to disclose, whether or not a house is haunted to a potential buyer, considering it could affect the property value, for better or for worse? If you were the buyer, would you want to know if you're buying a haunted house? I want to hear your thoughts in the comments section below. If you like paranormal romance and urban fantasy, you should check out my book, Blood Moon, book 1 of the Crescent Crown saga. It has demons, witches, vampires, lots of action, and a steamy romance. Link in the description below. Please like, subscribe, hit the notification bell, and share this video with your friends. Legally Drunk is possible because of viewers like you. Watch out for ghosts when you are house hunting, and have a very spoopy and happy Halloween. Catch you in the next one.
Can I have a job application? I brought my own spatula. I called earlier, but I hung up because I was nervous. Do you have references?
Wait! If that was you on the phone and you on the bus, then who was flickering the lights?
Nosferatu!